Good afternoon, members. Welcome you all to the meeting of the panel on administration of justice and legal services. I now officially call the meeting to order. First of all, I would like to report to you that since the last meeting, we have received one paper, CB bracket 4219/13-14-01. It's a letter dated the 5th of December 2013 from Standing Committee on Legal Education and Training. In fact, we have wanted to invite the chairman of the Standing Committee to attend our meeting today, but they have turned down our invitation. There is a reply to that letter. Please also take a look of the items for the next meeting. We'll be getting a briefing on the policy address, on the 2014 policy address. Our meeting will be held on the 28th of January, a Tuesday at 4:30 p.m. We have got two papers here, CB bracket 4225/13-14 as well as bracket 02, one being a list of outstanding items for discussion, the other being a list of follow-up actions. For the next meeting, when it's speaking, we'll get a briefing from the we'll get a briefing on the CE's policy address. The SJ, the Director of Administration, as well as the Secretary for Home Affairs will brief us on the policy address. The second item will be the Administration of Justice Miscellaneous Provision Bill. In fact, on the 23rd of July this year, there was a discussion, but the members had a lot of points to make, so we have to have another discussion again, and that's why at the next meeting we have allotted a time for this bill. So members, do you agree to two items concerning the January 2014 meeting? If you do, then perhaps I need to seek your consent to extend the meeting to 7 p.m. so as to enable members to have ample time for discussion. So members, is it agreeable to you concerning the agenda and the meeting to be held until 7? And that takes us to the third item on the agenda. The Law Society of Hong Kong has a proposal to introduce a common entrance examination in Hong Kong. I've sent out the following papers to you. CB bracket 4225/13-14 bracket 03, which is a paper provided by the Law Society of Hong Kong. Yeah, the Bar Association has also sent in a paper and has been tabled. It was faxed to us today. And then there is this paper, CB bracket 4234/13-14 bracket 01, joint submission from the Faculty of Law of the University of Hong Kong, Faculty of Law of Chinese University of Hong Kong, and the School of Law of City University of Hong Kong. Well, the Law Society of Hong Kong, towards the second half of November, issued a consultation document. And in fact, the title of this item has been slightly adjusted in line with the title of the consultation paper. So it is a matter of whether there should be a common entrance examination, being a proposal from the Hong Kong Law Society. At this moment, I would like to invite the various guest speakers to join us. So, I would like to declare I'm a student of the City University. I have suspended my studies. I had no intention to enroll with the PCLL. I would like to study law just for the sake of interest, but I've suspended my studies. Mr. Liao, Hong Kong Ju, and Mr. Yip Kok Kim as well. Who else? I'm on the council. Yes, I need to declare. In fact, I'm teaching at the School of Law of the City University of Hong Kong, but I'm not teaching any programs under PCLL. I am a PCLL graduate of the University of Hong Kong. Any other declaration of interest for members? No? Then I would like to extend our welcome to the various representatives from the Bar Association, from the Law Society of Hong Kong, as well as the 3 universities. We have also invited the Department of Justice to be represented at today's meeting as well. Well, I would like to point out that at today's meeting, whether in the form of oral submissions or written submissions, you will not be protected by the Legislative Council Powers and Privileges Ordinance. The Law Society of Hong Kong has issued a consultation document about the idea of having a common entrance examination. So first of all, I'd like to give the floor to the Hong Kong Law Society, since they are the proponent. So we are going to give them 5 minutes. For the other deputations, that is the university representatives, each of you can speak for 3 minutes, and then it will come to the time for members to ask questions. First of all, I'd like to give the floor to the Law Society of Hong Kong. Yes, Mr. Yip. Madam Chair, can I speak in English? Because the university representatives are English speakers, so it will be easier. Yes, in fact, let me say this. If you like to speak in English or if you would like to speak in Cantonese, try to stick to one language so as to facilitate the simultaneous interpretation service.
Inviting the Law Society to make representations on our proposal to conduct a consultation on the common entrance examination. I would like at the very outset to clarify one important item. The Law Society is conducting a consultation, and the consultation is about an entrance examination to test the standard of potential solicitors. It is not to replace the PCLL, nor have we proposed that it should be replaced. I must admit that the paths to becoming a solicitor are complex and difficult to understand. The fact is that despite us trying on several occasions to be clear about it to the media, it is unfortunate that what we are proposing has not been fully understood. Indeed, it would appear that the Secretariat to this panel might have equally been confused, and hence the original item on the agenda was incorrectly stated as to discuss the Law Society's proposal to replace the PCLL. No doubt that drew fire from the 3 law schools. Let me say here, once again, the Law Society is not proposing to replace or abolish the PCLL. The course remains a necessary step and qualification for a large proportion of lawyers entering our profession each year. And it is equally an important step and qualification for lawyers entering our counterpart at the bar. It will be important also to understand that when we say common entrance examination, it is really an entrance examination for the solicitor's profession and has nothing to do with the entry to the bar. It is not a common solicitor's and barrister's entrance examination, although if the bar wishes to engage in that direction, we would not close our doors to discussing that. Further, the PCLL course are taught and awarded by Hong Kong U, City U, and Chinese U. The Law Society has no intention of interfering with the academic freedom of the 3 universities in how they examine their students, just as the Law Society expects to have the freedom in determining how it examines the standards of those who wish to become solicitors and what quality we expect solicitors to have before they can be let loose, so to speak, on serving the public. Now, with that out of the way, I would like to say that the consultation is currently open and we are gathering views from a very diverse group of stakeholders and members of the public. It is therefore premature to talk about whether we should or should not implement the proposal for a common entrance examination. And it would not be appropriate for me to comment on the papers before the panel from the 3 law schools or the bar. I would like to invite those who have a constructive desire to express their views, whether for, against, or have alternative suggestions, to do that at an appropriate forum. The current system of admission was implemented some 40 years ago, where there was only 1 law school. Not only have the numbers of local and overseas law graduates increased substantially, but the scope and nature of work conducted by solicitors has changed drastically. These changes are accompanied by the increase in number of foreign lawyers seeking admission in Hong Kong and foreign law firms seeking to establish a presence here. The relevant legislative provisions to this topic are, of course, the Legal Practitioners Ordinance and the Trainee Solicitors Rules. The Law Society feels strongly that as a regulator for the solicitor's profession in Hong Kong, it has the responsibility and obligation to ensure that those who are practicing as solicitors in Hong Kong have achieved the highest standards and are of the quality that the public expects of us. It has the duty to ensure solicitors acquire the necessary knowledge and skills to meet the demands of consumers and the community, and that these skills are constantly updated and maintained at a consistently high standard. However, unlike our counterparts in the vast majority of other jurisdictions, the Law Society is not currently exercising its statutory power to administer the actual testing mechanism on that standard and quality for the large proportion of those entering this profession. The PCLL accounts for a large proportion of those who become solicitors, and I'm sure members of the panel are aware that there are many different routes to becoming a solicitor in Hong Kong, and I will not go into details here. The Law Society feels that there could very well be inconsistencies in the standards of entrance to the solicitor profession because of the different routes to admission. Even for PCLL itself, there is no certainty of consistency in standards, and I say this because, respecting their academic freedom, each of the 3 law schools has its own criteria for admitting PCLL students, develop its own law schools, develop its own curriculum, conducts its own course, and examines its own students subject to a set of benchmarks laid down by the Law Society. Now, Madam Chairman, I will only take another 30 seconds. The Law Society has received feedbacks from external examiners and practitioners and students that there are inconsistencies. And it is felt that it is time that we should carefully look at what should be done and what could be done. There is also the issue of the bottleneck. I mean, there is a bottleneck, but I would be happy to address that at another occasion. So, in closing, I would say that, contrary to what was alluded to, the Law Society does not wish to restrict entrance to the profession for numbers' sake by creating any artificial barrier to entry. However, it wishes to allow entrance to the profession to those who achieve the same consistent high standard that you and I and other members of the public expects of solicitors in Hong Kong. Thank you.
係，多謝葉律師。咁咧就跟住落嚟呢，就係請香港大律師公會。
Next, Mr. Chan from the Bar Association.
Working, I suppose it is. Now, the position of the bar is really set out in the proposed common entrance examination paper, which I think has been placed before every member here. And given the time constraint, I'm not going to go through it. But there are really a few things that I'd like to emphasize. One is that, of course, we realize that this proposed common entrance examination is meant for the solicitor's profession only. But it certainly may impact on the bar in 2 ways. One is, of course, that if the entrance to the solicitor's profession has proven to be too difficult and have proven to be too harsh for the student, then, of course, there would be the temptation for those who actually doesn't want to join the bar, who nevertheless would like to join the bar first, and hoping to switch to solicitors later on. Now, if that is the position, obviously it is very unhealthy. So we have got an interest to see that the students, there is no unnecessary barrier put onto the students from becoming solicitors. Now, I'm not really saying this just as a matter of empty talk or as a matter of theory. It did occur in the past that on a few years where the economy was bad and it was very difficult to get traineeship, the number of students joining the bar has got a sudden increase because there was no impediment from joining the bar. You don't have to be a trainee solicitor or trainee barristers and got paid. So this is something that we have got an interest. Now the other is, of course, the impact of this proposal on the university's desire to continue to invest in the education of the students in the PCLL course. I've just heard that it is not meant to be a replacement of the PCLL. But on the other hand, what is not clear is whether it is intended to make the PCLL a completely optional exercise, in the sense that it is a case that you can either take the PCLL or no course at all and simply pass the common entrance examination. Now, if that be the case, then of course, the PCLL is no longer a mandatory course, and of course, the number of students supporting such course will be reduced, and the university desire and the investment on the course would likewise be reduced. Now, these are very practical matters that we have all got to think about very carefully. The idea of having self-regulations to the entrance to the profession is obviously a noble one. But of course, here we're talking about public interest. And we have to be careful that this kind of examination is not seen by the public to be a kind of number control exercise.
OK， 多謝陳景生先生。咁跟住咧，我哋就請。
Next, we have Mr. Johannes Chan from Faculty of Law, University of Hong Kong.
Liaise with the Secretariat before that it's better that we share the 9 minutes between the three law schools. So I'll speak slightly longer on the joint submissions and then to be supplemented by the Dean of the other two law schools. The first point we want to make is that we are glad to hear from the Law Society that they assure that this common exam is not to replace the PCLL, but it's still unclear when this common exam is going to be held and whether it would have the impact of rendering the PCLL redundant. As we set out in our joint paper, the PCLL is a skill-based intensive course for a year. It is intensive training with most classes conducted in small group exercise. Small groups meaning about 10 students. They've gone through intensive practical training, advocacy and transactions, with also extensive involvement of the profession and the judiciary. The PCL programs are also closely monitored by the professional bodies, and the details have been set out in our paper. It has evolved over the years to reach this point, and this system has served us well. We are not aware of any major criticism of the quality of the program. Having said that, there could always be improvement, and all three law schools are open to suggestions for improvements, as we have always done. The professional bodies have set the benchmarks and we work towards those benchmarks. There's a common set of skills that all PCLL graduates would and should acquire. At the same time, there is more than a way to achieve the same thing, and legal training has to be flexible rather than dogmatic. And a slightly different program in all three law schools with a common core actually strengthened and enriched the quality of the program. The three law schools have also been able to offer different electives and to produce graduates with different strengths and interests. Hence, the short point here is diversity is a strength rather than a weakness. And introducing a common entrance examination is a major change to the current system, and we are not convinced that there are justification to make such a major change. We reckon that there's keen competition for PCLL place, and we like to emphasize firstly is there's no quota in any of the three law schools as to the PCLL admissions. Admission is and has always been by merits, and the benchmark is set by the professional bodies. In the last 2 years, there were about 650 PCLL places offered by the Free Law School together, with about 1,300 applicants each year in the last 2 years. And we say that a 50% admission rate is comparable to, if not better than many other jurisdictions. And secondly, the number is not fixed in stones. All PCLL providers are prepared to consider expanding the number of admissions if necessary, subject to quality and resources. However, unless we are prepared to go for a system that whoever reads law shall be able to be admitted, a line has to be drawn somewhere, and wherever we draw the line, there will always be people immediately below the bar. At the same time, as the Law Society rightly said, it is in the public interest to maintain a high quality of lawyers who, after all, form the backbone of the rule of law in Hong Kong. Thirdly is we understand the concern that it may be difficult for someone to get admitted to PCLL on a second attempt for no reason other than keen competition. We are prepared to consider ways to alleviate this concern. For example, Hong Kong U is prepared to set aside some places for this group of applicants who just missed the threshold marginally by taking into account other factors such as work experience. Chinese University and City U are also looking into these issues. However, our joint experience shows that the number of qualified candidates who are otherwise excluded by the current admission exercise is only a small number. The large majority of candidates who are unable to get admitted is simply because they do not meet the standard set by the profession. On the other hand, a common entrance exam will make entry to the legal profession even more restrictive. It will not result in better lawyer, as an examination is no substitute for the current year-long systematic training with continuous feedback and improvements. The practical and systematic skills training in the PCLL course is not something that one can acquire easily by self-studies. No doubt there will be commercial providers who will come into the scene, but if it is difficult to monitor the current free tertiary institutions who are expert in education, how could one monitor a wider number of commercial providers with varying quality? And at the end, one will have to rely on the examinations, which will not produce better lawyers, let alone the affordability of such private, commercially oriented programs. It is also unclear when this common entrance exam is to take place. If it is to take place immediately after the PCLL, what could it add to the current PCLL? If it is to take place later, the benchmark has to be set out clearly, and what is expected has to be set out clearly, and it should not serve just adding another barrier to the entry to the legal profession. In short, we do not see any justification for introducing a common entrance exam. If there were any concerns about the current PCLL program, this could have been resolved within the current system. And furthermore, the Standing Committee on Legal Education is conducting a comprehensive review of legal education and training, including the traineeship stage of the solicitors. It would be most undesirable to introduce any change to preempt the review by the Standing Committee. So that's the joint positions of the free law schools, and maybe my colleagues from Chinese University could add to the submissions. Thank you, Chairman.
Thank
you, Mr. Johannes Chan. Do the other schools have anything to add?
Only a very few comments to add to what Professor Chan has said, since, as he's explained, the law schools are, in very general terms, in agreement on most of the issues as we currently understand them. I think the difficulty we have at the moment is that it's not clear whether the Law Society's concern is about the quality of what is already provided in terms of the bridge between the academic stage and professional training. And if it is a matter of quality, then there are mechanisms to address that. And I think it's very important to remind everyone that our PCLL programs operate within the quality assurance mechanisms which the universities apply to all of their academic programs, and they are also, of course, as has been mentioned, under scrutiny by the Law Society as well. If it is a question of numbers, and we do hear about the bottleneck, then there are a number of very important questions to be considered here. First of all, how many trainees do we feel we need to deliver into the professional training within Hong Kong? If we remove the so-called bottleneck, then we will be simply displacing the issue because there is every risk that we will have a lot of young people who have gone through their law degree and other forms of training and still can't get access to professional practice. I think the question of the bottleneck is one which really depends at what stage you decide to impose some control over access to the profession. And I think finally we can't ignore the question of cost. If there is to be an expansion in the number of PCLL graduates, then that is a cost that has to be met. At the moment, the majority of PCLL candidates in Hong Kong are UGC funded, although the distribution of UGC funded places differs across the three law schools. And if there is not to be an increase in UGC funding, then we are faced with the prospect of expanding self-finance numbers at precisely the time that the universities are being very closely monitored because of their self-finance numbers. So there are a number of difficulties that face us all here.
Yes. Professor Lin, Acting Dean of School of Law.
Emphasize one point, that is the introduction of the common entrance exam proposed by the Law Society is a fundamental change to the current system, and it deserves careful and serious consideration. So far, the only justification we've just heard is to ensure the consistency in standard. And I think the justifications need to be well articulated, and whether that only justification is enough is, I believe, still very controversial. And also the consensus building process is very important before the introduction of the CEE is actually brought. And currently, the Standing Committee on Legal Education, as Professor Chan has mentioned, is going to conduct comprehensive review. I think that will be the proper channel and for to build the consensus, because all the stakeholders are represented on that committee. Thank you, Chair.
Thank you. Next, I would like to give the floor to Mr. Wong from the DFJ, Mr. Peter Wong. Thank you, Madam Chair. In relation to the Law Society's proposal to introduce a CEE. Currently, we haven't got a firm position. We're still having an open mind approach to follow the views of the different stakeholders. Currently, the Standing Committee on Legal Education and Training hasn't got the time to look at this issue. This is a very important issue. Therefore, the panel's meeting is a very good forum. In fact, the Standing Committee has got extensive representation from the judiciary, the DFJ, the three law schools. We have also got laypersons, the Bar Association and the Law Society, as well as the Education Bureau as well. So we hope that that would be a very effective forum to look at the matter, so that we find the best approach to provide legal education and training, so that we can take up the challenges and meet the needs of the legal services in the 21st century. Thank you, Mr. Wong. Thank you for commenting on the proposal. Now, the floor is open to members for questions. To be effective in terms of time management, for those who are interested in asking questions, please indicate your desire to speak. 2 members so far have raised their hands. Who else would like to speak? Who else? Yes. So far, 4 members would like to speak. I would give each member 4 minutes time. Yes, and Mr. Martin Liu. If more and more members are wishing to join the queue, then perhaps we need to shorten the time slot for each. First of all, Mr. Chen Kam-lam. Thank you, Madam Chair. Madam Chair, I'm not a lawyer, but to me, I think this question has often been referred to among my lawyer friends. Mr. Yip, the immediate past president, gave us a briefing, and other speakers also told us about their views. Mr. Yip hasn't got the chance to give a reply to the points made by others. Now I want to raise a few questions. You mentioned that for the CEE, it is going to be an open examination, a public examination. You don't intend to replace the PCLL with it. But how are you going to operate it? Because there will be concerns about the future standards. Some students may want to sit the CEE, but then they're not taking a local course at one of the 3 universities, nor at one of the universities in the UK. So how are you going to set a standard which can satisfy everybody so that no one would get to become worried? Now, for your proposal, does it mean that because the 3 universities are not providing enough places so as to train enough graduates for us? Is that the reason, or is it because there is a matter of interest? Just now, Mr. Edward Chan told us that in the case of a public examination, it would mean that the university programs will no longer be attractive and they may not be able to continue with the PCLL programs. So can you sort of go to the core of the issue? Yes, Mr. Yip. Allow me to try to answer Mr. Chen's question. Mr. Chen asked in Cantonese, so I'll try to answer in Cantonese as much as possible. Thank you, Mr. Chen. Your first question was the standards of the PCLL and also the standards for the CEE and how they are set. Let me first of all explain the matter. Currently, we have lawyers who don't have to take the PCLL and have become solicitors. They have the OLQE. They have taken the OLQE and they have become Hong Kong solicitors. So some solicitors haven't taken the PCLL. However, the majority of the entrants to the legal profession have gone through the PCLL. Even if they have completed a legal education in overseas countries, they come back to Hong Kong, they take the PCLL, they sit the PCLL exam, and then they become a solicitor trainee for 2 years. That is, then they start the trainee solicitor contract for 2 years. Now, we are having a consultation exercise. The nature of the consultation is that we would like to get views from different quarters so that we can fine-tune our proposal. Now, you put this question to me as to how it is going to be conducted and how we're going to set the standards. I'm afraid for the time being I cannot give an answer. We hope that by getting input from the consultation exercise, we can elaborate on this point and we can sort of tell you more later. But generally speaking, for standards, we are looking for unified standards so that all the graduates will have the opportunity to sit for the same exam. So that's the starting point. Your second question was, is it because there is a lack of places at the universities and that's why we have come up with this proposal? The answer is in the negative. For the CEE, can you really resolve the problem of inadequate numbers? Maybe not. But initially speaking, we believe that maybe this proposal can address a number of concerns, one being the number of places. Next, Mr. Dennis Kwok. Thank you, Madam Chair. I have a few points to make, and I would like to seek clarification with the Law Society of Hong Kong. right from the beginning, you said that the CEE would not be replacing the PCLL. You repeated it a number of times. So the inadequacy of PCLL places would not be resolved. There will still be the problem of a bottleneck. So if there are still inadequate PCLL places, then for those with a law degree, it means that they're still not able to join the profession. So PCLL places would be an issue, and I would like to put the question to the 3 universities. That's the main point I want to make. Now, if you say that you're worried about the quality of the PCLL programs, and you think that this is not adequate to address the quality of the entrance. But in fact, you always have close liaison with the 3 universities about the teaching materials, the mode of examination, and you've been monitoring them. So you do have channels, and you can make use of such channels to tell the 3 universities and press them to raise the quality. If you think that the quality is not good enough, why haven't you resorted to such a route? Why have you instead resorted to the idea of a CEE? And then for the legal education and training for the profession as a whole, please also take into account the views of the Hong Kong Bar Association. Of course, the CEE is meant for solicitors only, but then the Bar Association has said that they would like to continue with the mode of PCLL to train barristers as well. So for the 2 branches, be it barristers or solicitors, I think it is hoped that they would be trained within the same system. Take me for an example. I switched over from a solicitor to a barrister, while others the other way round. So to a certain extent, for both branches, we need a unified exam and the same sort of training. I think this is important. And then, before you actually answer my question, just now Mr. Yip told us that some lawyers had gone through the route of OLQE to obtain the qualification. Now, for CEE, in fact, CEE would also affect the OLQE. So please give us some data. For OLQE, every year, I want to know about the number of candidates and how many have asked for exemption. If I remember correctly, there are 5 papers. For each area, I want to know how many applications have been made to seek exemption and how many have got automatic exemption. So please give us a set of data. Perhaps at this moment I give the floor to Mr. Yu. Mr. Yu, thank you. First of all, allow me to answer the questions in reverse order. Mr. Kwok, do you have anything to add? No, not really. I just want to queue up for the second time. Let me take the question about OLQE. Sorry, for the time being, I haven't got the figures with me. It doesn't matter. Do it in writing afterwards, please. Yes. For your second question, you would like to know whether we were worried about the quality. Let me put it clearly. We don't feel that the new entrants to the legal profession have any problems with quality. We have never said that. It is merely that we are saying that for the entrance examination, now we have got 3 different universities having their own programs, having their own examination. They examine their own students instead of having one common entrance examination. As to the question of the bottleneck, well, perhaps the CEE may, I emphasize, it may resolve the problem of the bottleneck. If you say that there is a bottleneck, of course, to solve the problem of bottleneck, one being that we provide more places. If we provide more places, or we can have more providers for PCLL programs. But of course, if you want to have more providers, you need to amend the law. For our existing mechanism, the Law Society of Hong Kong does monitor the PCLL program of each university. But currently, we find it on many occasions we haven't got sufficient manpower to oversee the 3 different programs by 3 different universities. You know that 40 years ago when we first started, there was only 1 university providing PCLL program. And for the 3 universities, for the information that they have given us, this can be seen, for example, if we have more places, then the Law Society may not have sufficient resources to monitor their program, and this is true.
We are already at the stage that if there are more PCLL providers, we don't have the capacity to do so. To quote an example, there are more than 300 universities in the US, and they do not check annually, they check every few years. Well, it's not infeasible. I feel this is a good suggestion on the part of the universities, but we need to point out that in our American counterparts, they have much more members to do this work. And even though they have more than 300 law schools, ultimately each state they have a test not administered by the law schools. We do have some flexibility in time, but let's try to keep it within time limit. We have 3 more people in the queue. Jie Wei Chun. I'm not a lawyer. My understanding is that a lot of professional qualifications in Hong Kong, they have set these exams through the associations, and they can practice in Hong Kong. So I'd like to ask the Law Society, when universities teach students through the PCLL, it's been in operation for quite a while. So why have you come up with the CEE idea? Is it because of insufficient spaces? So if school spaces are insufficient, shouldn't you target it at from that perspective? Because what I heard is it's not a quality problem. The relevant professional organizations also communicate very well with the universities regarding curriculum and so on. So I hope the Law Society representative, could you elaborate, because I don't quite follow your proposal for another examination, even though I'm aware that there are professional organizations that set their own exams. Thank you. You are correct. It's been effective, and why do we raise this issue? Well, even though it's effective, doesn't mean that we can't do a better job. The Law Society feels that it needs to seek improvement. We started with 1 law school, and now we have 3 law schools. We also have a lot of channels to enter the profession. In the past, students would take an LLB. We now have another program, the JD, the Juris Doctor program. The lawyers' work over the decades has changed as well. We now have different competition. We have foreign lawyers for foreign law firms in Hong Kong. We also have a lot more students. So that's why we put forward this review proposal. Can I follow up? Does that mean there are insufficient university spaces? Are they saying they should increase the number of spaces? Well, of course, you can add more university spaces. It was asked previously. If we add more space, If we add more seats, the bottleneck will be in the profession. Well, I don't rule out that possibility, because even if that were to occur, the bottleneck arises from public demand, not because 1 or 2 or 3 universities control the supply. Next, Mr. Abraham Sheikh.
I'd just like to share with the members here, visitors here, some statistics provided by the Government of Hong Kong Education Bureau. In the year between 2011 and 2012, the admission to PCL program, of which Professor Chen was right, is about 40% against the total application. But this 44% doesn't tell you the whole stories, as all statistics are lies is how you use it. Okay? So of the 44% that have been admitted, only from Hong Kong, students with applications based on local law graduation qualifications, 44%. In respect of students with application based on non-local law graduations, is also 43%. So basically, you're talking about a bottleneck. You actually, the universities have created a openness in accepting students, particularly JDs and all the other students, encourage them to do law, but at the end of the day, with the same amount of money given for different positions by UGC, you have admitted 43% of Hong Kong students from non-local. That signifies 2 aspects. First is you have considered the overseas graduates are better than Hong Kong graduates. That's one of the deductions you can make. So why you admit so many students? Is it because of greed for the power of money? That you encourage people to spend 2 years, 3 years to pursue a law degree, and you flung them out at the last minute? Is the university, with its aim of education, provide education and at the same time provide people for Hong Kong? And now you have admitted them and they graduated. May not everybody have a first degree, a second honor, higher. You have actually debarred them from, you are there for education. You are not there as a filter for the professional for the professional bodies like the bar and the society. And I must congratulate the Law Society for taking the greed out and look into this whole problem of qualification. My first question is to CityU, why your last dean supported this concept of consultation on the CEE? Why the sudden new dean have actually fall into line with the 3 universities? Why the 3 universities need to get together? You are not operating the same system of training. You're not operating the same type of program. Is it because of money that you want to protect your own self, the system? You are debarring thousands and thousands of students over the year. You talk about public interest. What kind of public interest are you? On one hand, to train them, and on the other hand, to play God to disallow them to join the profession. Rightly so. The Law Society, in its last 2 paragraphs, if I may just read from the last 2 paragraphs, which is really interesting, that you are protecting your home profession. In the paragraph 14, but even with the increase in the places, there will always be someone who just misses the threshold line. Think. You are now successful. Think of the people who like to be successful and being just chucked out. And then furthermore in the paragraph, so as there are more people who want to join the legal profession than the professions could absorb, there will be a bottleneck somewhere. In life there is always a bottleneck. It would be a greater waste of resources if someone is to have taken and passed the qualifying examination and only to find that he is not able to secure pupillage or a trainee contract. Who are you to decide? Let a common examination be for them to decide whether they can do it or not. At least then they can at least have this fairness. In Hong Kong nowadays, this society is talking about equity. It's no longer talk about who you decide to join and who you don't want to join. In your next paragraph, in reality, for those who are really dedicated to join the legal profession in Hong Kong, but are met with such misfortune of not being able to join the PCLL, all is not lost. He can still get qualified elsewhere and later gain admission to the legal profession here via the OLQE or BQE and so and so. Do you realize that a lot of those students borrowed money to study the JD, to study the LLB part-time? They don't have the time, nor do they have the means to go through to have the luxury that you are looking for a head to a head not. That's really, let's have a heart for our younger generation. While we are admitting a lot of foreign lawyers, we are denying a lot of local trained, qualified to be lawyers without the profession. And this is exactly what the Law Society is trying to amend. This is exactly the Law Society is trying to give those people a chance. They didn't say that they're not going to have PCLL. They didn't say that they're going to replace PCL. Exactly. If you look into the Law Society document, which I doubt whether you people have read it or not, they are just proposing a method of equity, of fairness, and giving the young people of Hong Kong a chance. I thought this university was supposed to train young people. Yes, you have trained them, but you have denied them. It's by merit that you have taken into the, please don't shake your head, I'm just expressing my view. I thought professionals are all open-minded. Okay. I'm not a professional, I'm not academic, but okay. I might be wrong, but at least I'm expressing my opinion.
Time's up, Mr. Abraham Sheikh, if you don't mind. The 3 law schools will have time to respond. I would like to give other legislators time to ask questions. Next, we have Mr. Liu Qianggong.
I find the presentations today somewhat disappointing. I do not see any presentation advanced from the point of view of public interest, but sound more suspiciously like vested interest masquerading under the guise of public interest. Now, Professor Chan and Professor Lin of Hong Kong University and City University mentioned this proposed comprehensive review of legal education training by the Standing Committee on Legal Education and Training. Now, that could be the right way forward, because I certainly will not, because I was considering seriously the proposal advanced by the Law Society, but until I heard about this proposed comprehensive review. That could be the right way forward. But that comprehensive review proposal has been on the table for some time. And so far, I have not seen any progress on that. So I would hate to see any unnecessary impediments to be put in the path of that comprehensive review. Now, since that most of the stakeholders here would have representatives on the Standing Committee, I was wondering whether someone can provide me with the information regarding the timetable or whether there's any target dates for that comprehensive review to be conducted by the Standing Committee will be completed. Thank you.
幾位關於法律教育上設委員會嘅時間表做呢一個嘅
timetable on the Legal Education and Training Standing Committee. Professor Johannes Chen.
Met, and in this recent meeting, the Standing Committee decided to launch this review. Second, the Standing Committee has already agreed on the terms of reference of this committee. Thirdly, the Standing Committee has a preliminary discussions about the consultants and the compositions of the review panel. The Standing Committee is looking into the financing of this of the review, and this is the matter to be discussed in the next Standing Committee meeting, which will be held later this week.
好，仲有冇其他幾位？廖長江議員，你仲有時間。
Mr. Martin Liu, you have time left. Sorry, I would like to ask about the timetable as well as the target dates. So, Mr. Liu would still like to know about the timetable of the review of the Standing Committee, since the universities are all represented on the panel or the committee?
I think actually, so far as the Standing Committee on Legal Education and Manpower is concerned, the greatest impediment at the moment is finance. The reason being that, as I understand, as a member there is not going to be any government funding for the study, and therefore that committee is looking for certain funding. At the moment, they are looking for the fundings from the Conversion Examination Board, but whether they could be successful in so doing is a matter which has not yet been decided.
Okay, Professor Christopher King.
I would say that as to the best of my knowledge, and of course I'm not speaking on behalf of the Standing Committee, but no timetable has yet been agreed for the committee's consideration of these inevitably very complex issues. But I think it's very interesting to hear that there is support beyond the law schools for this as the vehicle for considering the best way to look at these issues.
好，跟住咧就係阿何俊仁議員。
Next, Mr. Abajo. Thank you, Madam Chair. I'm also a legal practitioner. If I may share with you my observation. I remember that many years ago, but I can't recall when, probably 20, 30 years ago. At that time, entering into the legal profession took many different forms. There were many different channels. You could have studied at a local university or a Commonwealth university, and then you took an exam. Now, probably you studied at a university in the UK, and then you took the Part 2 examination. Of course, there were many examples of successful practitioners, and some of them became judges, and many of them did not even have taken the exam, and then some of them graduated from elite universities. And gradually, more and more have got the qualification. And then there is a voice to say that we need to raise the standards. And then it has become a rule to say that, first of all, you must have a law degree before you can sit for the Part 2 of the exam, that is the PCL. In the 1970s, there was already the PCLL. And later on, the rule said that you must have gone through a Hong Kong PCLL program, and then we have got the 3 providers in the form of the 3 universities. So this is aimed at assuring the professional standards of the entrance. Therefore, other than the LLB, you still have to take the PCLL, and you study at one of the 3 universities. As far as quality is concerned, I don't see a lot of voices. I don't hear a lot of voices challenging the quality. On the other hand, there are doubts as to whether we can assure quality concerning a common entrance exam. And then we've also identified another problem. I run a very small solicitors firm. I've got 8 or 9 solicitors. But we have got 5 paralegal officers, all with university education from the UK, from Australia. They perform very well, but they're not getting admission to the PCLL program. This is because perhaps they were not able to get the right level of performance. Say, for example, they have only got second class B, or they have third class only. They wondered whether they should resit it again. I said, you have completed your university education. There's no way for you to get a better result. Then people start to ask me whether they could have taken an LLM program, and then they were told that it might not be automatic. So what I want to tell you is that there is this group of young people. They are really disappointed. They are depressed. They have been performing very well, And for those who used to have good exam results, they might not perform very well. So this group of young people wonder whether they can be given an opportunity. Therefore, if you have a open exam, a public exam, of course you will be imposing stringent requirements to make sure that the standards won't be low. Then I'm wondering, why won't you give them another chance? And then there are people who have to work. It is impossible for them to set aside a full year's time to take the PCLL program, but they're confident to sit for a common entrance exam, and they don't mind if they have to do it again and again, but they are confident that they can pass it. By having a public exam, it means that the examiner or the marker won't know about the identity of the candidates. But in universities, the professors, lecturers would have different ways to supervise the students. But then for a common exam, it means that there won't be this relationship between the teacher and the student. So there is an aspect of fairness here. So there would be some people who would favor having a common entrance exam. For the PCLL, I think it should be preserved. We treasure it, and we understand, appreciate the achievement and contribution of the universities, but perhaps we should consider having an alternative channel. Mr. Ho has used up all his time. Mr. Poche has raised his hand, and I myself would also like to ask a question. So perhaps we should draw a line here, and then after that, the guest speakers can give an overall reply. James To, and after that, there won't be a second round of questions. Mr. Poche, I did not intend to speak in the beginning because this is but the initial consultation. But then, in the light of what Mr. Albert Ho has said, I would like to say something in reply. I won't be using the same sort of strong language as Mr. Abraham Sheikh, but in fact, so far we haven't heard any reference to public interest. And we haven't heard from candidates who have set the exam for many years and still failed, and we haven't heard from anybody who would very much like to join the profession and hasn't got a chance. Just now, Professor Johannes Chan talked about the success rate of candidates. Now, you talked about 50% being the admission rate out of 13,000 candidates. Can you not give us a better breakdown? How many of them are the local graduates of the three universities, either JD or LLB, vis-a-vis overseas graduates? And if they're not local graduates, not overseas graduates, what about late achievers or part-timers? They have got a degree from other sources, but they would like to get PCLL. And then to address a point made by Professor Chen, he said that somehow there would be a bottleneck, whether it should be at the university, that is at the time when you move from LLB to PCLL, or professionally when you move from PCLL to either the barrister's branch or the solicitor's branch, or whether after training and whether they will secure a job or not. I think in Hong Kong we are quite unique in that the bottleneck is from LLB to PCLL. So it seems that you have got one chance. Once you can't pass the bottleneck, you will never get a chance again. In overseas countries, the experience is different. As Mr. Albert Ho has said, there are many young people, especially those who don't have a first degree in law, but then they have put in a lot of efforts and they have got a LLB or they have CPE. They find it very difficult to move from LLB to PCLL. Now, for the Law Society of Hong Kong, they have already made it clear that they are not here to replace the PCLL. They just want to provide an additional route so as to give them one more opportunity. So we need to be very cautious here. At the end of the day, demand and supply, standards, and operational details. Well, we don't operate in a vacuum. Well, many graduates have graduated from the UK, and then they have dual-track systems. They have CBE as well as university programs. And there's one more point that I want to supplement. Whether we're talking about the local PCLL or training in Australia, I think, other than saying that PCLL is very practical in nature, I think it's sort of can be described as an extension of the LLB. Sort of you take up the remaining modules from the LLB. In fact, it's too theoretical. In the past, I had the opportunity to be trained in Australia. It is totally different. And I had the experience or privilege of barristers. So it's very different. Now, if the PCLL still claims that it is very practical as a program, I'm afraid I cannot agree totally. I still have an open mind about this point. We all want to move forward. Next, Mr. James To. Madam Chair, I agree with Albert Ho and Paul Chair. For Professor Chen's reference to a bottleneck, I do agree with him. Otherwise, the development of the profession may not be taken forward in the best way. Perhaps there can be a mechanism to say that you don't need to have the PCLL before you go to CEE. There are people who have the LLB and then they become paralegal officers like those in Albert Ho's firm. Now for the CEE, if you can set the standards at the reasonable level, and if you put in place certain prerequisites, then at the end of the day, either you have someone going directly from PCLL, and then you have another route that is by way of CEE, and then you sort of set a number as to the optimum number of professionals in the profession. But I don't know about the implementation of the CEE, whether you would attract too many candidates. Perhaps you have to look at the resources available. You have to set the papers, etc. You may have some difficulties, but perhaps it won't be difficult. You have so many universities. Maybe we can ask the universities to take turn to set the exam papers. Then perhaps this can work. Now, if we get a CEE providing a second option, so that you don't need to go overseas to finish your education, then perhaps we should also consider the downside or other disadvantages. And I want to know whether there are any grave concerns concerning this second route. Mr. To has got some time left. Who would like to answer his question? If I may just make a few brief remarks. Now, why we are having a consultant's report? This is because we want the stakeholders to give us comments telling us that for the so-called CEE, if it is to be launched, how it should be taken forward. At this stage, we haven't got the details, like how many candidates, who will do it, and who will set the papers. We haven't got such details. I think we should look at the broad principle, that is whether we need a CEE. The Law Society has already made it clear we've never intended it to be a replacement of the PCLL. As to whether there are lots of complaints concerning the teaching quality, no, there hasn't been such. However, there are many students, even when they're studying for PCLL, they may have a slip and then they can't pass the PCLL exam, and then that's the end of it. They might have undertaken the course, but they are not able to complete the course or complete the exam, then that's the end of it. Now, for the consultants, now, first of all, a student must have LLB or equivalent, and then complete PCLL. We are not saying that you can only take CEE once only. In other words, there may be students who have taken PCLL, but then they would have more than one chance to sit at an exam.
To resolve the PCLL issue, could there be more institutions teaching PCLL? The Law Society feels that LLB is necessary. Some people ask, could we use the old regime, you don't need a law degree, so you just work in a law firm and take the exams? I have an open attitude, but at this stage, I want to focus on having an LLB first. So if we continue the PCLL, it won't affect the barristers because they are taking the same subjects. If the Bar Association feels that they cannot use the PCLL testing format to determine which candidates are suitable for barristers, this is not a big problem. Lastly, the Law Society understands the bottleneck issue cannot be resolved by the Law Society. It's the university admission problem. I have never thought that we could increase admissions because we're talking about money. Just now, Johannes Chan said the 3 universities could consider adding more seats. But that's not the problem. They take the same curriculum, but they have different tests. Even for the same subject, they have different test papers. So, to be fair, taking a uniform exam by the Law Society, and that is something what we're trying to do. But as I said, we want to wait for the consultant report, and I'm sure our chairman will invite us to explain further after the report is drafted. I also have some follow-up questions. Then I will allow the deputations to respond. First, I'd like to ask everybody, the Legal Education and Training Standing Committee, they have listed 6 areas. Do you think this is sufficient? We would want to improve legal education. So in their terms of reference, they highlighted 6 areas. Second, I'd like to ask everybody, you mentioned the 3 universities. Mr. Johannes Chan said that there might not be a quota, but there are demands in the profession. So the 3 universities, assuming, I'd like to hear your different views. For example, there's a PCLL, and the Law Society proposing to add CEE. So could these coexist? Could we increase the quota? Could we have the CEE? And does the budget allow for that? Is that your intention? And we have a lot of students now who have been doing quite well but didn't enter the profession. Can you give them a second chance? Can you provide another alternative? They might have done quite well, but didn't meet the PCLL requirements. So I'd like to hear your views on this. So I'll now hand you the time. So first question is about 6 areas highlighted by Legal Education and Training Standing Committee. Allow me to try to answer. The Standing Committee discussion area, well, they've already conducted discussions. I think after this discussion, they feel this is sufficient. The Bar Association, Law Society, and the 3 universities have representatives in the Standing Committee, so we have participated fully in the discussion. The second question was if seats were increased and we have the CE together with the PCLL. I had mentioned just now, if you increase a lot of seats and if we have more PCLL providers, can the Law Society, under the existing mechanism, supervise all the standards? We might not have sufficient resources, but at the same time, we should focus our resources on the CEE. Other resources, used to monitor the universities could be relaxed. If you increase the seats from 2,000 to 10,000, we might be able to cope. Okay, time's up. So we now allow the law school representatives to respond or continue to express their views regarding the previous discussion. Mr. Johans Chan. Well, we've talked all afternoon about what problems we want to solve, and I haven't heard what we're trying to solve. We know there's no question about the quality of PCLL training. Then we're talking about seats. The Law Society don't have enough resources to supervise, or the 3 schools have different tests. Well, we haven't been able to put our finger on the problem. If you can't identify the problem, we can't say whether the CE can solve the problem that we haven't identified. So aside from the US having 300 universities, the UK has more than 20 universities with different tests, and they have 1 law society monitoring it. So we agree with the Law Society. We should consider different options in regulation. Well, we mentioned that in the States, they don't do it every year. They might do it every 2 or 3 years. Currently, we have lawyers in their spare time doing this work. So should we have a full-time person or department to monitor legal education? The second question is about, can we have other channels for entering the profession? Mr. Albert Ho asked, can you become a lawyer without an LLB degree? The problem was there were very differing standards. After years of efforts, we now have LLB requirements and PCLL. Well, we feel they need to have PCLL qualifications. We need more than an LLB degree. We need a good honors degree. So to respond to Mr. Abraham Sheck, do we have a lot? Have we excluded a lot of people? It's because they haven't reached the qualifications. some 50% of the 1,300 cannot pass exam. They might have just barely passed. Some might be third-class honors. Some don't pass the conversion exam. These are the lowest requirements. So having a CE, does that mean we relax all other requirements? But we're still facing the same problem. And lastly, do we have insufficient seats? We didn't hear a lot about this. We agree that some people, when they don't get good test results, they need a second chance. So the three universities are willing to look at this. We think that we could use a method other than the CEE, but CEE would bring about a lot of negative impacts. It might make it more difficult to enter the legal profession. That is my response. We have limited time, so I hope that you can conclude your response in 2 minutes. The Bar Association feels that there is no definitive reason. We don't know what the Law Society is trying to do. The second, what I've heard today is that when I see the CEE, my first impression is everybody has to take it, otherwise it's not a common exam. But now it seems that we need a parallel exam with the PCLL. So that is a separate issue. I hope you can consider carefully, what do we want? Any other response?
Two very brief comments. We've had a number of very important and interesting contributions from the panel this afternoon. I think one thing that becomes clear to me is that we haven't been, in the universities, particularly good about telling people what we actually do in the PCLL. I'm afraid that I would have to take some exception to the observation that the PCLL is too theoretical. I know from my own direct experience in examining in the PCLL that it's anything but theoretical. It's meant to be hands-on, it's meant to be skills-based, and my general impression is that that's exactly what it is we do and what we strive to. We can always do better. I think we'll all have to concede that. And I think that how can we do better is perhaps something that will come out of the Standing Committee's review. I think that the suggestion that the universities are stashing away large amounts of money from the PCLL, I think really can't go unchallenged. The PCLL, frankly, is not a money maker. At least in my own faculty, the PCLL operates effectively at cost, at break-even, and I think once we are under pressure from the UGC to revise the cost of the PCLL, then that all may have to change. But at the moment, the PCLL is not a great money maker. I might also add that we do not pack the PCLL with students from outside Hong Kong. I have my own figures right in front of me just now, and in 2013-2014, only 15% of the admissions to the PCLL were non-local graduates. 85% are local graduates. So I think it's very important that as we go forward in this debate, and I'm sure we can come back to many of these issues, that we bear in mind that there is a strong evidential basis for what we're doing. Thank you.
Yes, thank you, Chair. Just two quick comments. I think today's discussion is about really a very important issue on how to train future lawyers and admit future lawyers in Hong Kong. Okay, whether we are going to use CEE or by exam in the States or follow our traditional course of PCLL. So if you remember a few months ago, and we made a response to a JD student's complaint about this issue, and which was published in the Hong Kong Lawyer. And the three law schools' position is actually open on that particular issue. Depends on the consensus of the society. Okay. If the two branches of the legal profession can reach the consensus, and plus the Hong Kong society can reach the consensus about the future, of course, any changes can be made there. And so it's not really we are defending a sort of vested interests here. And the second point is the real thing about for the introduction of CE is the justifications, and several other commentators have already mentioned. We are a bit confused now. What's the exact justification for the introduction of CE? I think that needs to be debated and a consensus need to be reached. And the last point is about the admission of non-local students. It's much more complicated. It's not within the university's sole control, actually, because that's relating to the Hong Kong SAR's legal education policy, and also relating to the admission policy. I remember about 15, 16 years back, the admission to the bar needs, the applicant needs to be a permanent resident, need to be here for 7 years. Okay, but now that has been abolished. So it's not the university's control, it's relating to the whole Hong Kong SAR government's policy. Thank you, Chair.
係，跟住係得第比。
唔係，我話俾你聽，因為我想。
I just want to follow up. I need to explain. He is confusing two issues. A lot of Hong Kong students do not have a Hong Kong law degree. They are Hong Kong people. So you can see the education department figures are here. 20% for foreign students, but these are Hong Kong students who get a law degree from overseas. They're not taking the JD/LB. So Professor Yip has confused that.
Next, I think we need to give the floor to Mr. Wong from the DFJ. Just now, I think Mr. Edward Chan said that there wasn't money for the review. So please tell us more about this. I think just now mention was made about the financial arrangements for the overall review. I want to say that all along the crux of the matter is whether we can use the money in the conversion company. But we haven't ruled out the possibility of using government's money. The Standing Committee will continue to look into this matter. Today we're able to get views from different schools, but I'm afraid that we need to collate the views expressed today. First of all, whether we need a CEE, and if yes, its relationship with the PCLL. There was a question as to whether both could go hand in hand. So, in terms of a relationship between the two, I think there is a chance for it to be revisited. The government is open-minded about this. We are concerned about legal education in Hong Kong, as it will have direct bearing on Hong Kong becoming a high-quality legal service center and a center of arbitration and other sorts of dispute resolution. Well, for the issue, I think this is the initial discussion. This is because the Law Society's consultancy report hasn't been completed, and then the Standing Committee's review hasn't been commenced, and then we would like to talk to the Standing Committee to see if it is the financial problem or other problems that are standing in the way. We want to know about the progress. It will be more facilitating if we have got some findings from an objective study. And secondly, I believe that when the Law Society's report is ready, and when the Standing Committee has got some progress about the review, then I'm sure this panel will decide on the follow-up. Deputy Chair, so many questions have been asked today concerning the subject matter of consultation of the Law Society. I just wonder whether the Law Society can forward a copy of the draft report to all the stakeholders as well as this panel. Let's have a round of discussion before the report is to be finalized. Can this be done? It seems that we have asked many questions. I think we all agree that the questions have to be answered. Mr. Yip. Paul? I have reservation about Dennis Kwok's proposal. I don't think the consultation report from the Law Society mandates anything. I think it is simply something from the Law Society. I don't think the Law Society should be made to show the draft to others. On the other hand, I think it's better for us to have an open process. This is the better forum because it is a public forum and then others can also speak. Mr. Chen Kam Lam, I agree with Paul Chair. Moreover, for the Bar Association as well as the 3 universities, I just wonder whether you can consider the following. For the sake of the legal profession in Hong Kong, for the sake of our standards, well, it is a fact that the 3 universities test different things in your exams. Is it possible to come up with a single exam so that PCLL candidates of the 3 universities will sit for the same exam? And then together with the CEE of the Law Society, candidates of the CEE would also take the same exam paper and also allow students who failed in the previous year to take the exam again. Would it be possible? I think we should try to work in this direction and try to seek a good solution to the problem. Abraham Shack, Madam Chair, through you, I'd like to ask the Secretary for Education. Well, in fact, the Education Bureau has already given us many figures concerning the admission of candidates. Well, from such figures, you can see that you have admitted candidates who are Hong Kong residents, but they've returned from overseas studies. I think it has brought up a very big issue concerning quality. Today, we have this item, and in fact, I'm grateful to the Law Society for tabling this proposal because it is a matter of public interest, and we need to be fair and open. Perhaps we should have an opening up. Other than the 3 universities, the other universities should also be allowed to run PCLL. And we can have CEE in parallel. In the 1950s, the Communist Party allowed for different schools of thought to thrive. I think we can do the same. Thank you, Mr. Chair. We have a very lively debate today. I'm sure we have the chance to come back to this issue again. We have already overrun today, and I know very much that you want to give a reply. I thank you for your attendance today. I'm sure there will be more opportunities to allow members to understand more about the operation of the legal education programs. Thank you.
好，跟住落嚟呢，
Next, Statute Law, Miscellaneous Provisions Bill. For the relevant paper, please refer to CB bracket 4/225/13 to 14 bracket 04, a paper from the administration. We have also invited other LegCo members to attend our meeting. First of all, I would like to invite Ms. Adeline Wen, Senior Assistant Solicitor General, to join us. She will also give us a briefing on the paper. And then, after the admin has given us a briefing, we'll open the floor to members for your questions.
首先呢，就係請尹平。
Ms. Wen. Thank you, Madam Chair. All along, the administration has got this practice from time to time. Say once every few years, we will submit a statute law miscellaneous provisions bill containing different proposed amendments to various ordinances. Most of them are technical and not so controversial. For the statute law miscellaneous provisions bill 2014, we are following the same tradition. In this bill, of course, there are going to be many amendments, but mainly speaking, there are 10 of them. In legislative paper, CB bracket 4/225/13-14, bracket 04, the details have been set out. I'll be very brief in the introduction. First of all, this is about the crimes ordinance. We have learned T.C. William Roy against S4J, as well as S4J against Yao Yuk Long. We have got these two cases. In both cases, the local court has already declared that certain provisions of the crimes ordinance breaches the basic law as well as the Hong Kong Bill of Rights. So the Security Bureau would like to amend or delete or repeal certain provisions which have been declared unconstitutional by the court. The second one is about the 4 pieces of legislation against discrimination. First of all, certain items in Part 2 of Schedule 5 to the Sex Discrimination Ordinance will be repealed. Second, the ECO can serve on persons certain enforcement notices for discriminatory practices under the DDO. And then to provide protection to the members and staff of the EOC against liability when they act in good faith in the performance or purported performance of any of the EOC's functions under the DDO and FSDO. The same protection is already provided in SDO and RDO. And then we'd also like to refine the Chinese text of some provisions of the 4 pieces of legislation. They originated from the EOC and has got the agreement of the CMAB and the LWB. For the third item is about the evidence ordinance. First of all, notarial act or instrument. This is upon the request by the Hong Kong Society of Notaries, and we would like to say that a notarial act or instrument of a notary public registered in Hong Kong may be received in evidence in civil proceedings in the courts of Hong Kong without further proof as duly authenticated in accordance with the requirements of the law unless the contrary is proved. Another item is, well, under the Mutual Legal Assistance in Criminal Matters Ordinance, we have got some major proposals from our major partners. Therefore, the DOJ would like to introduce legislative amendments to the EO and the MLA in criminal matters to render foreign public banking, routine business, and computer records obtained pursuant to a mutual legal assistance request admissible in the courts of Hong Kong as prima facie evidence of any fact stated therein if they are annexed to a deposition, affidavit, affirmation, or declaration made according to the law of the foreign jurisdiction concerned. The fifth item, coming from the judiciary. Currently, Section 81 of the Evidence Ordinance currently empowers judges and judicial officers at various courts and tribunals in Hong Kong to bring up any person in lawful custody before the courts or tribunals to enable such person to prosecute, defend, or to be examined as a witness. But then there's been no reference to JJOs of the Lands Tribunal, so we would like to amend the law. Moreover, the judiciary would also like to amend Section 6A of the Lands Tribunal Ordinance to make it clear that their temporary members will exercise all the jurisdiction and powers of the tribunal and perform all the duties of a member. As to the sixth, as well as the seventh one, they were the proposals from the Law Society of Hong Kong. there was the Legal Services Legislation Miscellaneous Amendments Ordinance 1997, so that solicitors' firms may operate as limited companies. At that time, whenever local lawyers and foreign lawyers are mentioned, they have been regarded as legal practice entities, and that would include solicitor corporations. Now, in the case of trustees, trustees must be natural persons. Solicitor corporations cannot be trustees, so we're going to have an amendment to reverse it. The seventh item, again from the Law Society. Now, currently, when there is a disciplinary hearing against a lawyer, then the Law Society may say that there can be a suspension of a solicitor's practice or a foreign lawyer's registration pending the decision. The Law Society thinks that in appropriate circumstances, this can be revoked or restored.
Up till the decision of the Solicitor Disciplinary Tribunal. The next amendment is raised by Commerce and Economic Development Bureau. That is in relation to a Court of Final Appeal case, Lei Dou-nei versus Hong Kong SAR. It declares that the Section 26 Bracket 4 of the Trade Description Ordinance must be read down as imposing merely an evidential burden on the accused, with the persuasive burden remaining throughout on the prosecution. So we propose to amend Section 26 Bracket 4. The Ninth Amendment relates to Unsolicited Electronic Messages Ordinance. The Communications Authority has very narrow powers. They require a notice to be sent by registered post. We now require two more options, either delivery by hand or sending by ordinary post. The last major amendment is the Building Management Ordinance. Under existing provisions, a member of the Management Committee of an owner's incorporation is required to lodge a statutory declaration within 21 days to state that he's qualified. But this statutory declaration has to be made before a Justice of Peace. People found that inconvenient. So the HAB suggests that doing away with this statutory declaration, so they are just required to make a written declaration. This will include technical amendments, and I won't go into that here today. So you see, I have a lot of colleagues with me today from the relevant Policy Bureau, and if members have any questions, they are willing to respond. Thank you, Commissioner. So we now invite questions. I'd like to ask, once again, who would like to ask questions? Mr. Tan Ji-chun. We allow Mr. Chan 5 minutes. First of all, we need to thank the DOJ for amending Section 118, the legal age for homosexual acts. These were deemed unconstitutional in 2005, and the appeal had been turned down in 2006. We're now in 2013. This amendment is 2014, so it's been 7 years. Why did we have to wait so long? That's my first question. Because the government dragged its feet in repealing these unconstitutional ordinances. A lot of male comrades don't know what the legal age limit is. They have been thinking it's 21. In fact, it's 16. So not just the ordinary public, even the frontline law enforcement officers don't know. The frontline officers are still using the repealed law to arrest males who have conducted intercourse who are under the age of 21. So I would urge you to tell your frontline staff this has been repealed in 2006, even though the judges will dismiss these cases, but it's hard to fault them. This month I have received, the police went inside the house to conduct an arrest, so I hope the administration can deal with this as soon as possible. But these amendments and repeals are unconstitutional legislation in 0607. So if anal sex is brought down to 16, then 118D refers to anal sex for between people under 21. That would be unconstitutional, but on this occasion, this has not been handled. So in 118, it's just limited to male, but not heterosexual acts. But if we're looking at the principle of equality, it's suspicious of being unconstitutional. So how would you deal with these suspiciously unconstitutional cases? So some homosexual people have told me that they are going to take the case to the courts. So what is the government's legislative timetable? So besides heterosexual inequality, sentencing for male-male intercourse, whether we're talking about maximum penalty or actual convictions, there's a big difference. The maximum imprisonment is life imprisonment, but the Security Bureau from 07 to 2011 have provided male-male intercourse, and the immediate prison sentence was 54.8%, with prison terms ranging from 9 months to 9 years. But having intercourse with girls under 16, sentencing has been between 3 months to under 6 years. So that is another source of inequality. Security Bureau. Ms. Kong. There are a few parts, and I'll respond. Starting from 0506, the relevant court rulings, I need to point out that the unconstitutional provisions, they have lost their legal powers. So regarding these provisions, the DOJ has not continued prosecution. Mr. Chan reminded us to notify frontline officers regarding law enforcement problems. We have already informed the police to update frontline officers. These provisions are not effective anymore, even though we want to update the crimes ordinance as soon as possible. Why has it taken so long? After the 06 court ruling, the Chief Justice and Secretary of Justice asked for an immediate review of sex crimes. The review was very complex. The LRC also set up a sex offense working group. The work is ongoing, and their review is actually very comprehensive, and they have some guiding principles. Their review is there should be respect of sexual autonomy. There should be no discrimination on sexual inclination. And in fact, last year their first part of the report has been issued. The second part of the report will be dealing with offenses where they are of the age of consent, but there's no discrimination between the sexes. We are waiting for the comprehensive review, but at the end of last year, the legal representatives, representatives from the legal industry urged us. So we agree that there should be a update as soon as possible. So we're now moving as quickly as possible. So aside from the amendments, aside from the unconstitutional provisions, we're also dealing with homosexual acts. So we need to review all the sex crimes, and we have participated in the LRC discussion. So when the LRC has a result in direction, we will make a decision as soon as possible. So, well, time's up, but I'll allow this last question. The LRC my understanding is they're moving as fast as possible. They had stated previously that it's very complex. They will move in 4 phases. The first phase consultation document has been issued. They are now engaged in the second phase. There are 4 phases. But I don't have an exact timetable. Chairman, the items 6 and 7 of miscellaneous provisions, these are not technical amendments, even though it's not a policy amendment, but isn't it controversial? Items 6 and 7, but you've bundled it under the miscellaneous provisions. Is that appropriate? For example, only lawyers can become trustees. Only law society decisions. Well, I think, have you consulted other stakeholders? And why would the government agree with a law society decision? You also referred to law societies revoking the suspended lawyers or overseas lawyers. So shouldn't you consult outside opinion rather than bundling everything into the miscellaneous provisions? Well, thank you for the question. In paragraph 1617, these were proposed by the Law Society. And let me explain the 1997 trust. They have not taken effect yet, even though it was endorsed in 1997. But law firms cannot operate as a limited company, so these provisions have not taken effect. According to existing provisions, the trust, if you engage a lawyer to be a trustee or co-trustee, you can only assign an individual, an overseas lawyer or a local lawyer. So the Law Society has probably considered that 2 years ago we had conducted a similar miscellaneous amendment. We had updated a lot of provisions. It's been more than 10 years since 97. So the Legal Practitioner Ordinance has been updated. The amendments in 97, we identified this problem and asked them, could you reconsider this position, whether a trustee could be done by a limited company. After consideration, they've decided to not change. They want to use the existing provisions. So from our perspective, since we already have the existing provisions, we feel this is not controversial. So that is paragraph 16. Paragraph 17, the legal industry in Hong Kong is a self-regulatory industry. We entrust the two bodies to regulate behavior. So when there are complaints from clients, the Law Society will convene a disciplinary tribunal to investigate the relevant lawyer. So in the process, if necessary, they might suspend the lawyer's qualifications until the final decision of the tribunal. So they're suggesting that there are different cases. Some cases might need a revocation of suspension. But we respect they are a self-regulatory industry, so
well, in fact, it is a matter of a disciplinary hearing of the tribunal, so we do not disagree with their proposal. Paul? Mr. Chairman, in relation to the Legal Practitioners Ordinance, are you referring to the general disciplinary hearings? I think for Section HA, this is about something else. I've got Section HA with me, so can you elaborate on the amendment? We haven't finalized on the drafting. We are still in the process of consulting the Law Society concerning the amendment. We are here to consult your views concerning the policy. Currently, they have the power to revoke. Currently, they have the power to suspend a solicitor's practice or a foreign lawyer's registration. But then it is a suspension. You have to await the finalization of the disciplinary hearing before you would decide on the revocation of the qualification in the most serious case, or the lawyer, when aggrieved, may appeal against the decision. So what we are proposing here is that before the completion of the hearing, in order to protect public interests, maybe they would like to revoke or restore a suspension. So perhaps the lawyer would be allowed to continue with his practice until the finalization of the hearing. We did ask them about the possible scenarios. Say, for example, a solicitor has been criminally prosecuted. In between, the criminal prosecution has been withdrawn. In this case, then there's no need to suspend the practice, so they would like to be given this power. Paul, the crux of the matter is whether the council has got the power to revoke and restore the suspension. They may go back and forth. That's not the crux of the matter. But then Section HA is about a special scenario. Say, for example, the accounts or a solicitor has got some physical illness instead of having advertisements or those things. So perhaps you should read your document more carefully before just giving an answer lightly. Thank you, Mr. Chair, for your question. Well, according to our understanding of Section HA, it covers many different scenarios, including whether a person still has the ability to practice, his financial position, whether he has got a criminal record, etc. So it covers quite a wide range. According to the Law Society, given the extensive scope, they don't want to be broad brush, and they have made reference to similar provisions in the UK Act. That is, when a solicitor may not be fit to practice, he may not have to be stopped or suspended immediately, as his livelihood will be affected. So perhaps we can consider adding a similar element. Sorry, I hope I haven't offended the officer, because I thought you haven't reread the provision. I think you need to understand the scope of the provision. As Anne has said, you can't just take the words of the Law Society. You have to defend proper interests. Yes, it is a self-regulatory profession. They have been given a lot of powers, but then you are a government department. You need to monitor them. You can't just give the Law Society whatever they have asked for. The Law Society is still the only organization which can conduct the disciplinary hearing behind closed doors. Don't you think it is about time to reconsider the matter? We will take into account fully public interest. As to the specific amendment, when there is a Bills Committee, we can go into the details. Does another member wish to speak? Anne? Madam Chair. Well, of course, there are many legal professionals here. I'm only a layman. However, I want to clarify one point. Paragraph 16 about trustees. After the amendment, I want to know about the position. What about trust companies? Does it mean that trust companies can no longer become a trustee? 3 minutes for UN, because you're in the second round. According to the Legal Practitioners Ordinance, for provisions related to trusts, currently we haven't got solicitor corporations. We haven't got solicitors firms in the form of limited companies. So we have got either a local solicitor or a foreign lawyer becoming the trustee. So I don't think it is appropriate for a solicitor's firm operating in the form of a limited company to become a trustee. In fact, we haven't amended the law. All the specific provisions haven't been amended. We are simply keeping the existing provisions. We are keeping the status quo. Well, I just want to point out that for the proposals in the government's paper, we are reminded to comment on the policy or the principles. As Ms. Wen has said, they haven't finalized on the technical amendments. Personally, I would like to give this advice to the administration. Please try to lumping together so many different provisions, whether they are technical or not. You give us one big batch of provisions, it will be difficult for us to give comments. I think this is also a matter of public interest. Of course, you talked about the BMO. You say that written statements can replace statutory declarations for management committee members. Well, in fact, before it comes into effect, you should tell the grassroots so that they know it in advance. So all things should go in parallel. So I do advise that next time, please don't wait for so many amendments to be taken up together. Perhaps you think that they're all technical in nature and you want them to be taken as one batch. I would rather have a reasonable volume, say having 2 or 3 amendments, and then it will be easier for us to discuss, and then it's easier for us to give you input. Mr. Leung Kok Hong raised his hand, so can I give the floor to Mr. Leung and then 5 minutes for both Q&A, because he's asking for the first time, and then I draw a line. Yes. We have got one more item. A question for the officials, so as to enlighten me. Just now, Mr. Raymond Chan referred to the matter concerning the LRC. You are saying that you have 4 parts, and they have got the first part only concerning the consultation. Do they have a timetable? And I want to know whether they are interrelated. That is, they have to move from the first part to the second, and then to the third, and then to the fourth. Do they have a cause-effect relationship? Otherwise, we have to wait for a long time. Ms. Wen, the Security Bureau can answer this question. Thank you, Mr. Leung, for your question. For the LRC's timetable, I'm afraid I have to refer the case to the LRC to see if they have an answer. But my understanding is that they would like to do it ASAP. When they last issued the first part of their consultation document, the response was that it should be taken as quickly as possible. So they're trying to compress it as much as possible. Well, rape or other sexual intercourse without consent, that's covered in the first part of the consultation. The second part is about protection, like assaulting children, people without the mental capacity, or offenses concerning the abuse of trust. So that's about the age of consent. The third group is miscellaneous sex offenses, and then the fourth one is about the penalty, as mentioned by Ray Chan. So that's the structure of the 4-part consultation. As to their specific timetable, my understanding is that they have to be sort of asked again. Do you know how long it will take? You don't know? No, I haven't got the information. The penalty, of course, will have to do with the first 2 parts. Well, the first one is about autonomy. The second one is about protection. I think they did approach us, say, for example, about rape, and then after making the changes, it will be difficult to prosecute. I think we have had the discussion for a few months already. Why have it been moving? Why is it moving so slowly? You are going to far-reaching effects on the rights of others. You don't want people to take you to court and have it declared unconstitutional, right? Thank you, Mr. Leung, for your question. I took part in the discussion of that working group. The working group has taken the matter very seriously. We've got judges sitting as members. We've also got members from the academia. We've got government representatives. It is a very complex issue, and we have to make reference to the latest progress in overseas jurisdictions, and their research has been most comprehensive. The influence will be huge, and there are a number of guiding principles, and it is quite different from the direction in the Crimes Ordinance in its original form. So we would like to look at the overseas reforms. And the reforms have taken different formats, and we want to know about the justification. So sometimes we have to write to the relevant jurisdiction to ask for the rationale. So a lot of work has to be done. And even in the first part of the consultation, they heard that the public would like it to be done ASAP. They try to compress the timetable. Is there a time limit? We're monitoring your performance. You need to come up with a reasonable timetable. Yes, I appreciate that it is very complicated. But how come that it has taken so long? Other than the fourth item, which is relatively easier, the first two would involve a lot of work. Mrs. Yes, I will refer your opinion to the LRC to see if they would come back with a reply as to why it will take them so long. Allow me to add, in the year 2006-2007, the working group was set up, and then they would like to have a comprehensive review of sex offences. But then from certain case laws, it was found that children were abused by people occupying positions of trust.
Some judges in their ruling said there's no protection for children. So they spent a few years to do a sex offense database. In 2011, the Security Bureau had completed the sentencing record, and they went back to study the issue. So I will relate your opinion back to the LRC. So regarding rape offenses, we had discussed this in our panel, and you've heard the views. I need to now ask, in this list of miscellaneous amendments, I need to ask, do we support the relevant bills? If you don't object at this stage, we agree, but I hope you do take on board the views mentioned just now. We now move on to agenda item 5, judicial manpower situation at various levels of court and long court waiting times. The paper is CB 4225/1314-06 and CB bracket 4225/1314 bracket 06. So I'd also need to report that the panel had visited the judiciary and met with Chief Justice Ma and had exchanged views. So let's invite Ms. Emma Lau, Judiciary Administrator, to take us through the papers. Thank you, Chairman. We have provided a document. It touches on two important issues: judicial manpower and waiting times. In judicial manpower, we have two reports. In the past, the judiciary had an open recruitment to fill some vacancies. In this area, we looked at past workload and future workload from 2011 to 2012. In this recruitment exercise, up till 1st of October, we have recruited 49 judges and judicial officers. The new recruitment exercise is being implemented, and I want to point out two issues. Chief Justice, after deliberation, he found that in the High Court cases, if recruitment is from the Bar Association, timing is very critical. In light of our past recruitment experience, it was done every 3 years, so our recruitment might not match with these professionals' desire to enter the profession. So Chief Judge has decided that we will conduct annual recruitment exercises. So hopefully we can attract more people into the judiciary. So aside from the Court of First Instance, where we have more recruitment, in the coming legal year, we'll also have more recruitment of magistrates and special magistrates. The next issue is about establishment. We've talked about past workload and future workload. In the last 5 years, from 08 to 13, the posts, we've increased 11 posts, from 182 to 193. At the beginning of this year, the Court of First Instance Chief Judge, after conducting the recruitment exercise, he had conducted a review of manpower needs. The results are two. First, we observe that in the appeal court of the High Court, we need more resources. The reason that appeal judges vacancies have been filled, but we still have a heavy case workload and a long case workload. We need to rely on extra manpower from the Court of First Instance. So after review, we observe that the appeal courts need more resources. We also looked at manpower needs across the courts. We found that we need more resources to strengthen training. In the short-term manpower shortfall and increasing complexity, we see court waiting times trends as well. In the paper, aside from the High Court, the other courts' waiting times are near the target times. The High Court has the highest pressure. So in the short-term manpower shortage, so aside from deploying resources to shorten waiting times, I'd like to mention that in the case scheduling, we've taken some measures. We've given priority to high priority cases. So we are able to alleviate some waiting time. So which cases need priority? First of all, criminal appeal cases. So even if we have manpower shortage, the waiting time is in line with the target. The magistracies also have high priority. We time to retain waiting time at the target level. Lastly, we also have some special cases. If due to time constraints they have, and according to judges' instructions, they can get priority. Sometimes the handling time is lower than our target time. So this is our short-term measure to deal with the workload. But in the long run, that we stated in the document that we need to strengthen the judiciary establishment. We continue open recruitment until the vacancies are filled and we can improve waiting times. So that would conclude my report. Thank you, Ms. Lau. I'd like you to indicate we have 2 members with questions. 3. 4. So 4 minutes. Mr. Michael Tian. The fair, equitable, independent judiciary mechanism is part of our core values. A lot of people like to reside in Hong Kong. Foreign businessmen like to do business in Hong Kong because of this. But we see a shortfall in manpower. We have a 17% vacancy. That's a high level. The legislators had visited Chief Justice Ma. He explained that they want to maintain quality, so not everyone can be a judge. We asked, what about overseas recruitment? There are some language considerations, and it's not easy to recruit. So it seems that the 17% vacancy, we won't have a solution. In paragraph 5, you say that we will have some temporary judges. So these temporary judges, these deputy judges, these are high quality personnel, but they don't want to forfeit their career to be a judge. So it seems that we need more of these high quality professionals to serve as deputy judges. So how do we persuade them? You've raised a lot of issues, but no solution in sight. There might be a lot of talent in the pool, so how can we have people serve 3 months, 6 months as deputy judges? And we also need to increase personnel in the economic services. There's not enough office space. Court rooms are not sufficient, and if you add these areas, then it exacerbates the problem. You fill vacancies and you add a department, then you need more space. So has the government provided more space, provided you with more resources? Thank you, Mr. Tian. First of all, in our open recruitment, we have overseas practitioners joining us. As I said just now, in the previous recruitment round, there are 49, and some of them are practicing outside, and it's a serious consideration to join the judiciary, especially for district court judges and above. They need to make a pledge to if they join the judiciary as a judge. They need approval from the CE to return to private practice. So this is a very long-term decision. So they make a very serious consideration.
We'll continue to attract more recruits. And then for the deputy JJOs, as the Chief Justice has said, he would like to get the candidates of the right caliber before he will make the appointment. In this regard, for many years, the CJ has been looking for the right candidates, and we have had different practitioners joining the judiciary, becoming deputy JJOs. In paragraph 18 of our paper, we have given an account, and Mr. Tian has said that we should continue to look for suitable candidates to become deputy JJOs. As to the third question, we are going to set up the competition tribunal in the judiciary. We have already enhanced the manpower, both judicial and non-judicial. We need extra manpower. We need extra space. The judiciary has clearly informed the executive of this matter. We know that it is being positively examined. We have made it clear as to what needs we have got. They are actively looking at it, very active. Do they have any specific plan? Mr. Dennis Kwok. For the shortage of resources and manpower is a problem. And even Chief Justice Ma admits that this is a problem, a serious problem. I understand that it is difficult to get high court judges. However, we can get ourselves ready in advance. Say, for example, the number of courts. It is said that for the West Kowloon court building, the West Kowloon Law Courts building, what about the High Court? Even if you can get the judges, where can you accommodate them? J.A., thank you for your question. For our vacancies, they have to be filled. If we are able to have substantive appointment, we have sufficient courtrooms and offices for them. So even if you get the 7 High Court judges, you still have adequate accommodation? Yes. Now, for the High Court judges, in terms of their workload, I think that's heavier than others in the judiciary. Even if you can fill all the 7 posts, you may still have a shortage, and you have to continue to recruit more judges. Now, given the development of the High Court and the fact that the High Court's facilities are getting worn and torn, do you have any plans to get new resources? J.A., for the case of the High Court, we are doing our best to enhance the resources. As to the work that we have done, we have already put in 3 additional courtrooms upon conversion of the lower floors of the High Court. Probably at that time, that was the only feasible option. And then, as I have mentioned, there is also something in the short term. We would like to get extra space for the competition tribunal. We would like to have 2 courtrooms as well as the support facilities and office accommodation. And for the needs in the long term, the CJ has said that we should work under his leadership to consider the matter. I have already reflected my concern to the CE. The judiciary needs more resources. And then another point is, as mentioned in your paper, you have the judicial assistant scheme. So it's like the assistants to the judges. Many judges have said that in many cases they have provided valuable assistance and they're helpful. And for the young lawyers, it is also a very good idea. But then for the past 4 years, the number of such assistants in any 1 year was only 5, 3, 3, and then 5. I think there is scope for further expansion of the scheme on judicial assistance. Please do expand the scheme so that even though you don't get all the judges' posts being filled, you still have sufficient resources and support. J.A. Thank you, Mr. Kwok, for his question. For the scheme on judicial assistance, we do agree that it is useful and helpful. Our target is to get 6 per year. In the past 4 years, and in fact, there was a selection panel made up of judges to select candidates. We believe that we can only get the most appropriate candidates, so sometimes we were only able to get 5 or 3 only. As accounted, as depicted in the paper, the CJ takes a personal interest in this matter. He personally examines the scheme. Mr. Leung Kwok Hong. For the scheme on judicial assistance, well, I've complained about the fact that some judges have asked others to look at the cases for them. Well, but I don't think you should allow them to look at the cases. You mustn't allow this to happen. So you need to strike a balance. Well, for the judges, if you have got judicial assistance, the judge may not have full trust in that assistant. In the past, it was a matter of doing it out of friendship, but then a person not fit for the job was asked to do the job. I found it odd and difficult to understand how come that if you would like to get 6, you are not able to fill the quota. You aren't sort of getting anybody who is very special. You just want to get bright and dedicated young lawyers. I think that would be the only yardstick. If you can't resolve this problem, then I would say that it is unreasonable. Now, C.Y. Leung is challenging us to take him to court. So you must make sure that there are sufficient resources in the court. Every time you come, we are in agreement with your proposal to get more resources. And then you're going to have the West Kowloon Law Courts building. But I don't think it is adequate. I would suggest that we have got another building. We get another building on West Kowloon Cultural District. If you ask the people of Hong Kong, we would all agree that we have less arts and more rule of the law. So why don't we have a super court building on the West Kowloon Cultural District? Dennis Kwok, would you agree it is an easy journey to travel from Admiralty to West Kowloon? Please follow the rules of procedures. It's Mr. Leung's chance to speak. I think we have got the separation of the powers. If the legislature thinks that the judiciary is not performing well, of course we will criticize the judiciary. If it is because of lack of resources, we will try to help. You need to press the executive. You need money, you need land. So, do you agree that a piece of land should be given to you by the government so that you have a court building? Now, for judicial assistants, you need to give them office accommodation, right? And then court cases are getting very different. And I was a defendant in a case, and I found that the high court facilities were outdated. The screen was too small. JA, for the scheme on judicial assistance, as stated in the paper, we would like to get bright, fresh graduates so that they can spend a year when they join the profession to work at the court, so that they can have eye-opening experience, they can understand the work of the court, and they can also provide some assistance to the appellate judges. They are mainly responsible for conducting research, and judges will continue to carry out their own work. So all judges will be acting in accordance with the law. There is no question of giving work in an appropriate manner to inappropriate persons. Well, I think a judge has asked somebody else to look at the cases, to examine the cases for him. Well, it is said that there should be more land for the judiciary, because last time it was said that you haven't got sufficient accommodation. Of course, for the long-term development, the CJ will lead us. For the West Kowloon Law Course building, this is part of the package. All right, Dr. Ann Chang, thank you, Madam Chair. The last time we came, I asked a question. I think my question hasn't been answered. I would like to know about the lawyers freshly recruited. How many of them were specializing in advocacy? I don't quite understand the question. Was it her who came? I think we have said that we would like to have a follow-up question. Yes, I want to know how many solicitors have been recruited and how many only knows conveyancing work. I want to help the administration. I want to know how to resolve the problem of manpower, the shortage of resources and space. We all treasure our treasury because, relatively speaking, it is independent and it enjoys a very good image in the world. Madam Chair. For the establishment of the GJOs, when you look at the establishments as well as the vacancy as of the 1st of December this year, for the CFA, we haven't got any vacancies. For the Court of Appeal, again, I don't see any shortage. All the posts have been filled, right? But then, members of the public are not satisfied. Say, for example, for the High Court appeals, it is said that the waiting time is long for criminal cases and even longer for civil cases. It is said that it takes 52 days from being listed till it is being heard. Is it the case? JA. Now I understand Dr. Zhang's question. I think she asked the Director of Administration, and then the judiciary was asked to give the information. I think we have given the information to the Director of Administration, but it doesn't matter. I think we can sort of give an answer again. We have been asked about the 45 JJOs recruited in March. We were asked as to how many were barristers and how many were solicitors. Among the 45 officers, 27 were recruited from outside. Among the 27 JJOs, altogether, 23 were barristers, 4 were solicitors. For the barristers and solicitors, all of them have the experience of advocacy. And then Ms. Zhang also asked a question about the Court of Appeal.
Even though we have full establishment of the 21 posts, but after establishment review, we feel it's not enough. We are deploying judges from Court of Assist for first instance, and the court waiting times are still not ideal. So in the establishment review, we feel we need to add manpower. I'd like to add that under this workload pressure and manpower shortage, the judge's instructions are we need to focus on criminal appeals. These people are, the majority of them are in imprisonment, and they need to be dealt with priority. So you see that we're on target with criminal appeal cases, and this is my explanation to reduce waiting time impact. There's been a document on 10th of December. It has the supplementary information the Judiciary Administrator has referred to. So on the next occasion, could they provide more information? I'd like to know in the last 10 years how many cases were waiting for appeal in the High Court. How many of them were 3 months short of being released from prison? Some people have served their term and appeal before it's their time to appeal. And if they win their appeal, then it's wasn't that fair to the person. So the High Court, do we really have such a shortfall of High Court judges? Well, okay. Ms. Emily Lau. On the 3rd of December, we visited the judiciary. We had met with the Chief Justice. This is a serious problem. Even if they could recruit someone, there was no office space. There are a lot of support personnel. We need planning, and I hope that the judiciary has put forward its request. So, can the administrator tell us that they've already made requests. And last week, in the Public Works Subcommittee, I told the administration the judiciary needs space. You need to coordinate with them. They registered my comments. So can the administrator tell us, what have you told the administration in terms of land requests and design? Regarding our short-term, long-term planning, the Chief Justice will lead this work. We have immediate requests that have been made and are under discussion. Regarding long-term work, we need discussions. But we thank your support under the leadership of the Chief Justice. We continue to review our needs at different stages. Thank you. So what does that mean? What do you mean? Do you admit there's manpower shortage, there's a lack of space? The document says that you were only able to recruit one judge. And in the court of first instance, the waiting times are very long. Do you understand the problem? Are you doing work to tackle the problem? In my report, we need more resources for recruitment. We've already forwarded this to the administration. We already have a view and made a resource request. Even if you are given the money to recruit, there's no space there's no office space. I think the Chief Judge said we have sufficient space for them to work. I think the Chief Judge is saying if we have more needs in the future, if we need to add, if we need to fill more vacancies, we need to consider space. We don't see that you have resources to meet society's needs. We're concerned about your planning, how you... We still have Paul Jie, referring to the document on court waiting times. The other courts don't seem to have a problem. They seem to be on target. But we see the Lands Tribunal, they overachieve their targets. They have very short waiting times. Is it because we have less cases? If so, should we deploy these resources? It's in Enclosure 2. In Enclosure 1, the vacancy. The Court of First Instance has 7 vacancies. In others, it's -8. So does that mean we have a surplus? Just now we heard that district courts and above, they have a tenure problem. There isn't a revolving door. But district courts and high courts, do they have similar problems? It seems that district courts don't have trouble recruiting. Third, looking at paragraph 16 to 17 the deputy judges in the last 35 months, the temporary judges, there were 57 deputy judges that did not continue. So when you recruit these people, have you considered, is this an ad hoc measure, a temporary measure, or is it a honeymoon period? What is the case? If not, then should you consider adding more judicial assistants? This is another case, another channel. So after a certain time, they might be able to join the bench. So will you promote this? For example, overseas there's judge school. So this might handle the question of quality professionals not willing to serve as judges. So whether our long-term resources and planning, it's ongoing. The details will be disclosed at appropriate times. Mr. Paultier also mentioned other areas. The land tribunal waiting time. In the last few years, the caseload wasn't that high, so they have shorter waiting times. We've done some work in the last year. We have reviewed the waiting times. We have also consulted the Court Users Committee. So we will report back to the panel. These are target times, and it's related to the complexity of the case. So we have to consider a basket of criteria. So we can look at the Lands Tribunal. Regarding the district courts, the issue is district court judges are the same as high court judges in rank. So in order to facilitate deployment, we won't just recruit high court judges. We will recruit district court judges, and district court judges can work as presiding judges in the high court. So the presiding judge and district court judge recruitment is conducted at the same time. So even though there are less vacancies, but they can be deployed from the district courts. So this is a technical deployment tactic. So in the response to Paultier, I'd like to extend 15 minutes because we have 2 members who wish to ask the second round. I'd also like to follow up, so I'd like to ask a few questions. This is the second visit on this topic, and we have targets for each year. This year it's manpower and waiting time. This seems to be a major concern. Just now the administrator mentioned you hope that in the appeal court you want to add resources. But I remember you said that you have the most severe manpower shortage. So is it appeal court or court of first instance? So how do you recruit. What is the recruitment system? We understand that legal practitioners, they do not join the judiciary for money. It might be job satisfaction. So they don't have sufficient time to consider a case. So should we focus on training? This includes Ms. Chang's question. We have barristers that specialize in different areas, not just conveyancing. We also have advocates, the judiciary assistant issue. It seems that a lot of legislators would like to regularize this practice, and such that our judges can have more time to make a ruling.
Therefore, I heard from the JA that you are now emphasizing the criminal cases, but then my experience is that labor disputes, libel cases, among other civil cases, have suffered most because sometimes it will take 5 years, 10 years time before the case eventually goes to the CFA and gets a final decision. So yes, for criminal cases, somebody's freedom will be denied, but then for civil cases, justice delayed is justice denied. So even for civil cases, you need to increase the manpower. So I hope the JA can give an answer. Thank you, Madam Chair. First of all, we've examined the manpower. We understand that the CA has to be given more manpower. For the CFI, the waiting time is long because CFI judges spend a lot of time at the CA providing extra help. Therefore, at the level of the CA, if we can have more resources for substantive appointment, then more CFI judges can come back to the CFI, and this will help. And in due course, we have to examine the need to provide time and resources to judges so as to prepare for cases and to be trained. So the CJ will lead us and will guide us in dealing with such matters. So that's why we have been saying that by dealing with the manpower of CFI, it can help with the case of the CA. And then you also talked about the working time. When we list cases, when we set aside time for a judge to prepare for a case and to write the judgment, well, we have got arrangements at every level as to how cases are to be arranged, etc. I think we have always been following the CJ's guidelines. In some cases, some judges have many complicated cases and they need more time to write their judgment or to read the documents, etc. Currently, we have a mechanism so that the judge and the CJ can have a discussion, and then the judge will be given extra time. Lastly, Madam Chair, you mentioned about the waiting time for civil cases. What I explained was that we agreed that the High Court's waiting time is long. It is unsatisfactory. We need to have more judges on substantive appointment, but we can't resolve the problem overnight. Therefore, we're going to give priority to the urgent cases. For civil cases, we have the same consideration. According to the High Court Chief Judge for the High Court, generally speaking, we give priority to a number of categories. First of all, JR cases, because they have to be dealt with in a timely fashion. Currently, we have got judges dedicated to dealing with JRs. If certain JR cases have to be heard first, we try to accommodate their timing. And so for JRs, the waiting time is much shorter than our target time. And then there is another category, like in the form of injunctions. Again, timing will be crucial. Therefore, for the time being, we will be following judges' directions. We give priority to those identified as urgent cases so as to reduce the impact. Thank you. Even though you are giving it priority, it is still unsatisfactory. Now, members waiting in the second round, Michael Tian, but then he has left the chamber, so I'll give the floor to Dennis Kwok. 3 minutes. I think the main point is that, of course, you have to continue with the recruitment exercise. But then the court building itself is limited in space. You can't get the judges first and then you try to find money to find accommodation. It takes 5 to 10 years to build a court building. As Emily Lau has said, you have to start thinking now. Singapore has already announced that they would like to set up an international commercial court. So we have to start thinking because others are already conceiving their future development plan. I'm glad to hear that more resources will be requested from the government. This is the first step. In other words, we're admitting that in the past we have suffered from inadequate resources for recruitment. Of course, the CJ has said that he would be happy to see more solicitors who have been dealing with court cases to join the judiciary. In other words, I would like you to tell us what have you done to prepare for more solicitors to join the judiciary. JA. Yes, we did discuss this question. Relatively speaking, we have more counsels than solicitors, but then there are also many solicitors who have the experience of advocacy, and they are joining the judiciary. I think the CJ also agrees, and time and again, we have also impressed upon members that for you to join the judiciary, advocacy experience would be very important. In the past, the solicitors did not have the right of audience at high courts. Now we have got a mechanism. Solicitors have already enjoyed the right of audience. Therefore, by having such a development, it means that solicitors will have more experience of advocacy, and in other words, there will be more potential candidates for appointment. Well, from the judiciary's point of view, as long as someone has got sufficient advocacy experience, we welcome the candidates, whether they are barristers or solicitors. Time is up, so I just hope that the JA will hear what we have said. We have already extended our meeting time today. I think the waiting time is indeed long. It is a painful experience to the parties to the case, irrespective of the nature of the cases. Now, you've said that you would like to emphasize certain categories. In other words, you have got inadequate manpower, and so the waiting time has been prolonged. On the 3rd of December, we talked to the CJ. We are all concerned about the issue. Now, There are so many lawyers in practice. So if you're more focused in looking for candidates, if you're more focused in providing training, I'm sure if you work hard enough, you can come up with a more concrete plan to fill the posts at the different levels of the course. As Ms. Lau has said, you need to give us hope. Everything is fine, but then the waiting time is indeed too long, and it makes us not competitive enough. You have to accept this fact, and it has generated a lot of problem, and the public have told us that they find it a painful experience. So how are you going to encourage more to join the profession? I think you need to exhaust more means to do so. I'm sure we'll come back to this item again, and I hope that the JA will come back again and give us more concrete details. Last time we got the impression that you haven't got sufficient accommodation. I think the judiciary should be glad, because few departments would be asked this question, that is whether you have got sufficient accommodation, whether you've got sufficient money. Emily. I think in the middle of the year we need to come back to this issue again, not just getting the JA, we should also get the Director of Administration. Would it be the administration wing or which department overseeing the problem? Probably by then you would have already had a word with each other to facilitate our discussion. I don't think I can answer the question on behalf of the administration. Perhaps they've got different personnel for different issues. Say for a 5-year plan, 10-year plan, if you had more judges, would you need more space, more accommodation? I think we should leave it in the hands of the executive. It doesn't matter, we can talk to the administration. We have got the views from the members. I think in 2014 we should have a chance to come back to this topic so that we can be more focused on the discussion, say increasing the number of judges, all right? Ms. Chang. I'm on something else. Have you finished? Yes, finished. What have you got to say? We all know that it is very expensive to have litigation. The middle class in particular find it difficult. Either you don't have any assets, and then probably you may be able to get legal aid. However, for those in the middle class, they don't get legal aid, and yet it is very costly to be involved in a court case. Well, if you lose a court case, you have to pay the cost of the opposite of the other party as well. Now, if you want to engage a lawyer, your solicitor may want to engage a barrister, and then the barrister will get a junior with him as well. It is awfully costly. I want to know whether we can discuss this matter. Do we need such a cumbersome and overlapping structure? Ms. Zhang, so you want to know whether solicitors and barristers and the division of labor, you want to know whether it will take one single lawyer alone? Yes, we'll try to see if this can be sort of lined up for discussion. In fact, the legal profession did discuss about it before. I heard Anne's point. I would like to thank the JA as well as your team. So I declare the meeting closed. Thank you.